Rafi is a partner here at Hanson Bridget, and he practices IP and commercial litigation. Thank you, everybody. Thank you, everybody. Really happy you're all here, and I just want to thank the panelists for taking their time to come. We really appreciate it. Looking forward to it. So the Armenian Bar Association is really focused right now on trying to encourage members to think about joining the bench and provide every opportunity, resources, whatever is necessary to allow its members to pursue an opportunity on the bench if possible. I think right now especially it's a very important time in it's a pressing time. The democracy sometimes gets questioned, and we're unfortunately in times where court orders are being defied. So I think now more than ever, it's important to encourage our own members to really pursue opportunities on the bench and to encourage those that do. I have the great honor of introducing an incredible panel as well as moderator. I'll start with Presiding Justice Helen Zukin, who earned her law degree at Loyola Law School. Before joining the bench, Justice Zukin's practice included mass toxic torts, product liability, environmental property damage, and healthcare actions. Justice Zukin was appointed to the LA Superior Court in 2018 and the Court of Appeals in 2023. Justice Zukin's community involvement is truly remarkable. I can go on for hours, but just to name a few, she is chair of the State Bar of California's Commission on Judicial Nominees Evaluation, chair of the LA County Bar Association Judicial Appointments Committee, chair of the United District Court, Central District of California Merit Selection Panel, and so forth and so forth. She's dedicated to devoting her time to everyone and anyone, and we really appreciate her making time for today. Justice Zukin was recently recipient of LA County Bar Association's 2025 Philip H. Lamb Diversity Impact Award. Not only that, she was also the recipient of probably the most prestigious award. Some may even say the gold standard. And of course, I'm speaking about the 2025 Armenian Bar Association Judges.
Piece of art on my chin.
Presiding Judge Tapia is the first presiding judge of Latino heritage elected by all the judges of the Consolidated Superior Court since trial court unification in 2000. He earned his law degree from the University of Iowa and College of Law, and his dedication to serve the community really speaks for itself. He began his career at the Legal Aid Foundation of Los Angeles, providing free legal assistance to self-represented litigants. He then joined the LA County Public Defender's Office as the Deputy Public Defender and later the Alternate Public Defender's Office before his appointment to the bench. He was appointed to the bench in 2013 and since then held several leadership positions with the court, including an assistant presiding judge, supervising judge of the criminal division, and on several committees such as the executive committee, budget committee, facilities committee, and so forth. He now heads the largest trial court system in the nation, and that's a huge task, and he's doing a phenomenal job at it. We also have Mr. Hofmann, Mr. Adam Hofmann here today, and he's serving as the Deputy Judicial Appointments Secretary in the Office of Governor Gavin Newsom. He also recently served as chair of the State Bar's Commission on Judicial Nominees Evaluation. Mr. Hofmann is no stranger to this office. He joined Hanson Bridget in 2006 and served as the co-chair of Hanson Bridget's appellate practice. His practice focused on representing cities, counties, and special districts and writs and appeals relating to public finance and revenue measures, land use, civil rights, employee benefits, labor standards, and election law. He also taught courses in local government and land use law as an adjunct professor at the University of San Francisco School of Law. Also have the privilege of our moderator today being Judge Michael Amerian. Judge Amerian is always eager to support Armenian Bar Association events. And for me personally, it's been a great pleasure to get to know him better throughout the last year at these events. Judge Amerian earned his law degree from USC. He clerked for the Honorable Dikran Tevrizian in the Central District of California, where he began to truly appreciate the responsibility of the judicial role. After his clerkship ended, Judge Amerian started his practice at a boutique litigation firm, and thereafter he decided to switch gears and spent 15 years as a deputy city attorney. He was appointed to the bench in 2018 and presides over the Van Nuys Superior Court West Department O. Judge Amerian is very proud of serving in Van Nuys, where he has vivid memories of being picked up from preschool and watching his father in court. Judge Amerian was initially assigned to family court, and he is now a civil trial judge. Despite a very busy schedule, Judge Amerian always makes time for us, and we're very thankful for that. This year, he received the San Fernando Valley Bar Association Judge of the Year Award. Again, I'm really honored to be amongst a great panel and moderator, and I pass over the mic to Judge Amerian to take over. Thank you.
Thank you very much, Tro. The goal of us all tonight is to demystify the process. None of us get to anywhere we want to go without having mentors and people who have traveled the path before us show us how to do it. One of them, I'm really humbled that he's here tonight, Judge Zaven Sananyan, who was a mentor of mine both before my appointment, there he is at the end, and after I joined the bench. He's always been somebody I could count on, and I only want to pay that kind of service forward, which is why I enjoy doing this type of work and speaking with a lot of you one-on-one. But I really appreciate our three panelists. This is like a triple crown panel here, and it's very humbling for me to sit alongside the three of them because I look up to them so much. And so our goal tonight is to really demystify the process, answer a lot of the common questions that potential applicants have. I see a lot of younger judges, younger aspiring judges, hopefully, and younger lawyers here. And that's great because you need to know how to plan your application going forward. We're going to talk about all of that tonight. So my first question is going to be for Deputy Secretary Hofmann. Can you explain the process that the governor follows, just structurally, and just what the stages of the process are?
Thank you, Judge Amerian. And I just want to echo thanks to the Armenian Bar Association for having me down tonight, to Rafi Zurian, my former partner, and to Hanson Bridget. It's very nice to be back here. And thank you all for letting me participate. And thank you, Tro, for the lovely introduction as well. So what was your question?
Yes, explain the basic steps.
So I'll give an overview. This is something that if we dug into the details, I could talk for an hour, which obviously I'm not going to do. But the thing to know is, first and foremost, every judicial appointment in California begins with an application. There's an application online. It's a terrible website, but it is online. And anyone who's thinking about this should go, I mean, literally Google like California Judicial Application. You will find the website. There's a PDF version that you can download so you can see the questions. It's long, it's detailed. And I encourage anyone to sort of wrap their head around it as a first step, okay? Because it does require, especially, you know, for younger lawyers who are thinking, maybe one day I want to do this, you can start thinking about putting the information together now, because it requires detailed information about the cases you've litigated, the judges you've appeared before, the attorneys you've opposed and worked alongside, as well as, you know, kind of some deep analysis of your own practice, your personal background. It's very thorough, okay? So start with that. Those applications then come to our office in the governor's office. And this is true governor over governor. This is all well-established standards. From there, we do an initial vetting. There's some secret stuff that goes on, deliberative process privilege and all that sort of thing. And then for many of the candidates, they're sent off to what we now refer to as the Judicial Selection Advisory Committees. Okay, these are folks like Justice Zukin, who sits on our Los Angeles JSAC, as we refer to it, They're appointed by the governor to aid in the evaluation of judicial candidates. They used to be, for those of you who've been around for a little bit longer, they used to be referred to as the secret committees. And that's because before Governor Newsom and then Appointment Secretary Martin Jenkins, the identity of the members of these JSACs was kept a secret. Okay. Now their identities are all public. So there are 8 of them around the state. 1 is devoted entirely to Los Angeles because, you know, Los Angeles. And you can see who's on them. The process itself, though, is entirely confidential. So when a candidate goes off to the JSAC, in theory, they don't know. Sometimes they catch whispers that they're being investigated, but in theory, they are not supposed to know. The JSACs then report to our office. They assign ratings, they give us a summary of their qualifications, and we do further vetting from there. Again, secret sauce being made in the governor's office. For those who are looking promising, we send them off. This is a step that is now required by law and has been for 40 years, 50 years. The
1974.
I believe that's right. And there's an interesting story about how that came about and why that date is so fresh for Justice Zukin, but we'll skip that for now. Anybody who wants to hear about it can ask me later. Required by law, every gubernatorial appointment has to go through the State Bar's Judicial Nominees Evaluation Commission. Okay. This is the first step when a candidate knows that they are being considered, because the first thing that happens is the Jenny commissioners who are investigating them will call them up and say, congratulations, you've been referred to the Jenny Commission. Now, you all know this because if you're barred in California, you get these emails periodically, right? Confidential comment forms, they call it. And most of the time, you don't know who the person is, you hit delete, it's fine. There are reasons for that. But if you know the person, please respond. The Jenny commissioners do an exhaustive investigation into every candidate they're sent. They interview the candidate. They deliver to the candidate any substantial, credible, and corroborated criticisms that come out of their investigation so that the candidate can then be, has an opportunity to address them and explain. Because, you know, we're all lawyers, right? You've probably made somebody mad in your life. It's just reality. The commission then meets, they discuss every candidate, they issue a report to our office, and part of that report includes a rating. Exceptionally well qualified, qualified, or not qualified. And I emphasize that not qualified because that is the only time that the candidate finds out what their rating is. If they're found not qualified, they are notified of that fact and they are given an opportunity to appeal. And the reason for that is because otherwise these reports are entirely confidential. But if a governor appoints someone who's been found not qualified by the Jenny Commission, that fact becomes public. So as you can imagine, that's a pretty strong disincentive for governors to appoint people who've been found not qualified. Governor Newsom has not done so today. Okay. So then the reports come back to us. At the same time, for Los Angeles, a few other counties, we also get reports from the County Bar Association. So these are all these different investigations all going on kind of at the same time. Some of the county bars will reach out to the candidates, others don't. They manage their own processes. All of this information comes into our office and we do still further vetting. Secretary Cespedes and I, phone calls, we reach out to people, we learn all kinds of things. We will know you better than you know yourself by the time this process is over. For those folks who are looking promising through all this investigation, they come into our office either by Zoom or in person. There's an interview. We then meet with the governor, make recommendations, and the governor makes the final decisions. And that's when it all becomes public. So that's the process.
Okay, thank you. How many candidates are known to the governor or Secretary Cespedes or you before they apply?
It's a vanishingly small number. And especially for the governor. Secretary Cespedes knows, I think, roughly half the people in California. I'm like amazed, you know, walking in, you know, you could be in like Colusa County and you walk into some restaurant and it turns out he knows like 12 people. It's amazing. I know a lot fewer. But, you know, we know a few of the folks, not very many. Some we meet at events like this. Others we've known from practice or otherwise. But even for us, it's, I would say, less than 5%. For the governor, I'm going to put the number at something less than 1%. You know, in my time in the office, I think there's been 1 or 2 people that he's appointed where he knew the person's name before we brought them to him. Okay. So I emphasize that because I think and I was talking to a few folks about this earlier, there's this sense that, you know, the only way to become a judge is to, you know, be in close with the governor. You got to know somebody who knows somebody, that kind of thing. That is not the way Governor Newsom manages it. My impression is that was not mostly how Governor Brown managed it. And my hope is that whoever the next governor of California will follow in Newsom's footsteps in that regard.
And is there any way for a candidate to know when they move from one stage to the next?
No, other than the Jenny Commission step. That's when candidates hear that they are in the process. Otherwise, and we talk about this a lot, it is a very counterintuitive process for lawyers because you hit send on this electronic application, you get confirmation that it was sent into the ether, and then there's just silence for months. Okay, and we're all lawyers. We're trained to chase things down, make sure we know what's going on. You know, is there anything I can do to push things ahead? In this process, there is a lot of waiting, and patience is the key word here.
All right, I'm going to ask Judge Tapia a very Los Angeles County specific question. Do you have a sense of how many vacancies will need to be filled, either through retirements or
Wait, I need to
what has to between now and the
I'll
end
email
of
it to you.
yeah.
So it's a great question because it's ever changing. You know, for years, we used to see on the LA counties, on the Superior Court of Los Angeles County, on average 12 to 18 vacancies a year. In recent years, however, that number has skyrocketed. Last year alone, there was a point in time where we had well over 35 judicial judge vacancies. Right now, we are at a low for this governor, which is 15. However, there's a caveat. 3 individuals were appointed, bringing it down to 15, but they have not taken their oath. The governor counts that as an appointment, so it's not a vacancy. But for us, it's still a vacancy because the person hasn't taken their oath and may not take the oath until December. So we have to cover
someone in the
courtrooms.
room.
Yeah.
So right now, we currently have 15 vacancies. My understanding is by the end of the year, assuming there are no further appointments, that number will go over 20 again. By the first quarter of next year, that number will creep up close to 30. But I'm going to assume that the governor will probably make some appointments before then. So it will hover around 20 to 25 until the end of this governor's term. And I say that because every governor, and I can't speak for this one, every governor at the end of their term does their level best to fill every single vacancy. So for those of you that are monitoring and looking at vacancies, it's a moving target. It's 15 today, it's going to go up. And I guarantee you over the course of the next year with the retirements that I'm expecting. In fact, I just had a meeting today where I was telling supervising judges, you need to tell me who's retiring. Even if it's 6 or 8 months off. I suspect that for the next 14 months, we will be averaging between 14 to 20 vacancies. And I'm certain the governor will fill all of them before he leaves.
Please. All right. So now often Judge Tapia, potential candidates are concerned that their practice area may not be valued by the court or the governor's office. I think traditionally we've heard this concern expressed by family law or plaintiff's personal injury practitioners. Can you tell us about the needs of the court and whether you communicate those needs to the governor's office and how that plays a role in the process?
So let me answer the last question first, which is yes. We have communicated our needs to the governor's office since the beginning of this governor's term. I can tell you specifically over the past 3 years, almost 3 years, since I've been the assistant presiding judge and presiding judge, we constantly have conversations with the appointment secretary, I know I do, about what our needs are in terms of discipline. But let me answer, I think, what is the most important question, which is those individuals that come from practice areas that traditionally may have been seen as practice areas where, oh, I'm never going to be a judge if I'm a family law practitioner. One of the wonderful things this governor has done is ensure that we are getting a diversity of practice when it comes to appointments. We've got more family law practitioners under this governor than I could ever remember. And that's a great thing. Because at the end of the day, for those of you that practice in our courtrooms, if you go into a civil courtroom, wouldn't it be nice to have someone in that courtroom like Judge Amerian that has that kind of experience? If you go into a family law courtroom, wouldn't it be nice to be in front of a bench officer that has a background in family law? Same thing for dependency, probate, you name it. Those are all wonderful things. So I think everyone, if you look at what this governor has been doing, you should be encouraged regardless of your practice area. I think it's beautiful for our system of justice to have that type of diversity. I'm very much committed to building trust and confidence in our justice system. That is one of the ways we do it, by honoring every single type of practice area and ensuring that people view every practice area with the same level of value. One of the things that Judge Jessner and I did when she was presiding judge and I was assistant presiding judge is really try to emphasize to our colleagues and to the bar the value of all of the disciplines that exist on our court. For far too long, we had people coming onto the bench that usually came from a criminal background or a civil background. Not to say that's a bad thing, but what did that say about the value that governors placed on those other disciplines like family, probate, juvenile justice, and dependency? Because I guarantee you, for the public that's coming into our courtrooms to address a family law matter, a probate matter, or a dependency matter, that is the most important thing to them. And that is how they are going to judge our justice system. So why not address that through the appointment process? Now, having said that, what I will tell you is, since I am the person who has to assign people to courtrooms, one of the other things that I think the governor does is when they find someone who's a family law practitioner, a civil litigator, a dependency lawyer, a criminal lawyer, what they're looking for is the very best within that practice area. Someone who has a skill set that can easily go into a courtroom that may not be their practice area. And I think that's important. I mean, I have some examples here in this room. You look at Commissioner Albanesian. She came from a criminal background. She is now sitting in what is, for all intents and purposes, a family law assignment, and she is hitting it out of the ballpark because she just has that skill set. She's smart, hardworking. She was able to do that because she possessed those qualities. Even though her practice area was in one area, it translated to being successful in other areas. Judge Wasserman, another example, someone who came from criminal. He has transitioned to family law, didn't miss a beat, again, able to acquit himself in that regard. So I say that because I don't think the governor is just looking to appoint family law attorneys or juvenile dependency attorneys just for the sake of doing it. They are still looking for quality attorneys because at the end of the day, when we do get appointments, my needs may not be consistent with that person that is coming into the door. And I have to fill a spot that may be a different practice area. And believe it or not, I think it's a good thing for that judge. Having overseen the discipline process for judges on our court, the complaint process, I think it's healthy for new judges that come in to do something different, to expose themselves to a new area of the law and learn how to be a judge and learn how to learn that new area of law. It makes them a much better judge. And over time, they will eventually get to that discipline that perhaps they really wanted to be in. But by the time they get there, they will know how to be a judge. They will have earned the respect of the public that comes before them. And at the end of the day, for our justice system, that is a wonderful thing.
Very well put. I think personally, the most rewarding part of the job has been how much it satisfies my intellectual curiosity. So if you have that kind of intellectual curiosity, it's a wonderful experience to get thrown into something totally new and learn from scratch. Justice Zukin, you have sat as the chair of just about every conceivable vetting committee that exists for any type of judge that exists. What do you look for within an application that helps you identify somebody with that sort of intellectual nimbleness and curiosity that would make a good bench officer?
Well, starting with the basics, look, thank you so much. Lack of typos. So make sure that the grammar is correct, that there are no typos, there aren't things missing from the application, because believe it or not, we do see applications that, and we serve on the same committee. We do see applications where it's basically disqualifying just based on the application itself. What do we look for in the application? We look for their practice area. We basically take in every vetting committee. You could look at whether it's the Jenny confidential comment form, professional experience, knowledge of the law, the different categories. Temperament is a huge one. We look for temperament because there is something which I know we've all heard called robitis, which is people that put on that black robe that have a problem with temperament usually get worse on the bench. So we're definitely looking to see what is their temperament. What do their opposing counsel say about them? What's their personal story? So that's a very important part of the application. That is your chance to convey who you are and why you want to be a judge and why you think you have the life experience and the characteristics to be a judge. But we look at the entire application, and we also look to see if anything important was omitted, because these vetting committees go beyond the application, right? They do a search on the applicants, generally speaking. So we look at everything.
Can I add something?
Yeah.
And I think this is important for all of you to know this. And I think you would agree with this, Justice Zukin. The JSAC committee, we merely provide a recommendation. So Justice Zukin is absolutely right. There are certain things we're looking for to make a recommendation to the governor, but there are no kingmakers in this process. And I think Mr. Hofmann would agree. The only kingmaker here is Governor Newsom. So our committee simply recommends. I think Jenny also makes recommendations, but the only kingmaker that exists in this entire process is Governor Newsom.
And we talk about that. We talk a lot in these kinds of settings about there isn't anybody but you really that gets you there. So although you may be gracious once appointed and thank people that you think helped you along the way, it's all about you. It's what's seen in your application. It's your body of work. It's who you are as a person. So anybody that you think has an in with the governor, you heard, it's not going to matter anyway. It doesn't matter. The vetting committees do their vetting and then goes off to the governor's office.
Judge McKeegan knows this because I told her when she got appointed. Who was responsible for your appointment?
You said I was.
Yes. Yes.
And the governor.
Well, we'll say the governor too, for sure.
So, I mean, you've told us about the range of ratings that applicants can get. What helps distinguish somebody from a qualified to an exceptionally well qualified in the eyes of these committees?
In the eyes of the committees? Well,
Yeah.
the committees are different, but let me speak at the moment, because at the moment I'm on the governor's committee.
Right.
The governor has criteria for the bench, right? We know what are the governor's priorities, and it has to do with who a person really is, right? Empathy, integrity. You may want to speak to this, and I'm happy to cede to you on this
Please
point.
go on. I'm curious to hear what Judge-
So we also vet with the lens of the governor. The governor's office has shared those values publicly and shared them with the committees, his committee. The government code for Jenny has characteristics they want you to vet. Can you quote those like off the top of your head? I think you
Pretty
can.
close, yeah, and it's 12011.5, government code 12011.5. But yeah, I mean, yeah, it's the things you've already talked about: temperament, work ethic. Now I'm going to lose it because you put me on the spot.
Shame on me.
Shame. Work ethic, temperament, community respect, bias, freedom from bias. Thank you. There's like 7 or 8 of them, honestly. There's a lot.
So let me say something. I'm going to take your question to a slightly different place. No application is the same. And one of the reasons applications are so different in terms of exceptionally well qualified, a big tome of what's in there, is because not everyone gets the same career advancement opportunities, right? So we recognize that. I know the governor's office recognizes that. Some people do not get the opportunity. They're not asked to serve on the LACPA litigation section executive committee. Some people are not, so they're not tuned in that way, just in the legal community. Some people don't get the career advancement opportunities in civil to be first chair trial lawyers, right? Need I say, women don't often get in the civil arena the same opportunities to try cases that some of the men do. It's just a reality. Also, fewer cases are getting tried, and that's also a reality. So the applications don't look the same, and a lot of it just has to do with the life experience and the opportunities people have. So don't feel bad that you haven't published something, that you're not an editor of some legal treatise. if you haven't had that opportunity, right, to do any of that. Some people get it. Often they're with big firms. Many people that apply and get appointed are not with big firms.
What is the number one reason people are found not qualified?
On every single vetting committee, state and federal, I have seen that the number one reason that people are found not qualified is poor temperament. What happens is if people are not flexible with opposing counsel, they're rude, they have a problem with their own staff, all of that comes out in the vetting. It just does. You're required to put down your opposing counsel on cases. Your staff may be contacted at some point. Know that it may be confidential, but the word gets out, right? And in an investigation, the investigation is followed till a reasonable conclusion. So if it comes up that someone is very abusive to their staff, well, you better believe the staff is probably contacted, even though they aren't on someone's application. So it really is temperament. That's the issue. So for those of you just starting out or new in your careers, know that civility is required regardless. But if you ever want to be a judge, remind yourself not to get upset with opposing counsel and to delete the email before you send it. Right? Does that answer it?
That's great. That's great advice.
Judge Amerian,
Any
could
context.
I tag on to that just
Sure,
real quickly? Because
please.
I want to kind of gel a couple of things that you just heard, which I think is important for the younger folks in the room. You no longer have to be a DA to become a judge. If you want to be a judge, the way you treat other people is going to come out. And to me, one of the things that means is that if you're looking at your career in the long term, what I would say is do something that you love. And I'm sorry, and as Judge Tapia pointed out, you're going to be evaluated in terms of the quality of your work. Have you done excellent work, right? In whatever area. And so to me, what all of that adds up to, and I'm sort of looking at like the younger lawyers and the law students and so on, like do something that you care about that doesn't make you miserable. Because your chances of being a judge, it's a little like, structuring your entire life because you want to play in the NBA, right? It's a vanishingly small chance that it's going to happen for anyone. So pick something you like that will allow you to have the presence of mind to be professional to the people you're dealing with, to do excellent work, and to not hate what you do day in and day out. Because the worst possible thing that can happen is you never become a judge and you have a career that you like, right? That's the booby prize here. And the flip side of that is if you do something you love, you're passionate about it, you're going to do it better, you're going to treat people better, and all of that stuff comes out in the vetting process. So that's my recommendation to the young people. Thank you for letting me add that.
It's fantastic advice because I often get folks coming to me after they've had a long career. And I tell them, well, your application's baked in already. You can't go back 10 years about that confrontation you had with a judge or opposing counsel. And it would be so, part of the problem is for those of us that never imagined ourselves to be judges, that we never thought this was a path, it's something we didn't think about. But really for those folks that are younger, that are thinking maybe 5 years from now, I'm going to apply, start thinking about how you treat other people, especially your staff. I often get calls from the governor's office saying, do you happen to know where this lawyer practices? And do you know people in that courthouse that I can call? So don't think that they're just going to call people in your application. They're going to call all kinds of people because they want to make sure that they appoint the right people.
May I take it in a slightly different direction?
Please do.
And then ask Mr. Hoffman a question?
You put me on the spot
Again, I know, but I've asked it to you before, so you'll be okay. When I was appointed to the bench in 2018, I was a certain type of partner in a law firm. I had great demeanor. I was very easy to deal with opposing counsel. I had good temperament. But when I started practicing as a young lawyer, I was a different person. I went to an all-male, aggressive trial lawyer, civil trial lawyer firm where I was watching a lot of screaming and yelling and things that they were doing and shenanigans. I thought that's the way you practiced law. I didn't have lawyers in my family. I had no idea. I started out a much more argumentative, aggressive lawyer. And a couple of years into it, I had this epiphany. This is not me. I'm not liking the way this is, but they were my role model. But I cast that off. So people change. I'm an example of that. I would have been rated not qualified, well, I would have year one. I wasn't qualified to even apply, but you know, my temperament was very different for a while until I understood it wasn't me and it wasn't how I wanted to be. But I would like to ask you a question. Is there a perfect candidate?
I have met one, and he just retired from the California Supreme Court.
No. Yes.
You know, but I say that out of respect for Justice Jenkins, but also just kind of making a joke.
He's an Armenian Bar Association member.
Is that right? Secretly Armenian? Is that right?
We've adopted him,
Honorary.
and he's adopted us. It's been a reciprocal relationship.
That's outstanding. But no, in all seriousness, there is no such thing. And the kind of thing that Justice Zukin just described is not at all uncommon. And sometimes, you know, I met with a lawyer yesterday, who's, you know, when I say I met, I mean, I interviewed, right? And they talked about their experience as a young lawyer being, it was actually the opposite of what you're describing. This person was naturally confrontational, naturally over the top aggressive, and had a partner who taught them to dial it back, to delete the aggressive email, to, you know, to not send the nasty gram. And, you know, in their first few years of practice, they had someone who tempered them, and they have had a better career as a result. They credit this person with making them a better lawyer, and they're a better candidate for it. But what you're describing is absolutely something that we see. You see it on Jenny, of course, someone who had the wrong idea early in their career. They cleaned it up. They, you know, practiced for years and demonstrate good temperament. All of us, I mean, the thing that the governor has said that Secretary Cespedes often quotes is the governor's recognition that we are all a work in progress, right? None of us were born judges. Some of us might have been born lawyers, but none of us were born judges, right? And you can grow. And the question is, what is your history? What does your work demonstrate in terms of that growth?
So just one last time to put you on the spot here.
Yeah.
So I've heard this before. In my 20s, I had a DUI. I've had no issues since. I'm just going to give you an example of, right? I've had no issues with alcohol, no issues, criminal conduct in 20 years. Should I not apply? Is that disqualifying? How do you respond to that?
Absolutely, you should apply. It is not disqualifying. And I will tell you, just for example, I won't give it a time frame, but there was someone who was appointed in the not too distant past who was arrested on a misdemeanor assault charge when this person was young. They have not had any issues since then. You know, demonstrated growth, youthful misconduct stuff. Again, none of us were born perfect. Governor Newsom understands that. The question is, who are you today, and what does your history demonstrate on that front? Not what was the worst moment of your life.
Is there anything that is disqualifying in terms of personal events?
That's hard to answer. As Justice Zukin was sort of alluding to, people are so complicated, right? But I do think, you know, again, we can look at, and as we've been sitting here, the other items in the Jenny statute have come back to mind. One of which is honesty, right? So, you know, part of the mix is a little hard to describe, and I probably shouldn't disclose too much, but you can imagine, right? If the kind of conduct that we're talking about is very recent, right?
Yeah.
It's one thing to have had a DUI when you were 20 or 25. If you had a DUI last week and it was your third in the last 5 years, that starts to look like more of a problem, right? If you have a history of dishonesty, and to what Justice Zukin said, something that did come up, I would say maybe second to temperament, is dishonesty in the application process, maybe covering for dishonesty that came out at some point in your career, right? Those are the kinds of things, you know, it's not one thing. It's kind of what do all the circumstances say about who you are today and what kind of a judge would you be?
All right. One question that I frequently get is what kinds of people should be listed as your references?
So for our purposes, and this is the one area where I feel like I can speak to Governor Newsom, I can speak to Secretary Cespedes, I cannot speak to what's going to happen in the future. Okay. And I think this is potentially highly changeable. But from my perspective, the people that should be your references are people who can speak to your qualifications. And if I can offer a little advice, people who you have contacted and ensured they know that you're applying and that they support your application. Okay. And I try to put it succinctly like this. I would rather see your secretary on your application than your Congress member. Okay. If it happens that you know your Congress member really well because you've done work for that person and you are good friends and neighbors or whatever, then that's great, right? But if what happened is your law firm posted a fundraiser and you pulled them aside and said, would you mind to write me a letter? And they send me a two-line letter that says, you know, Adam Hofmann seems like a great guy, you should appoint him, right? That's not helpful to us, okay? We're looking for people who know your work, who can speak to your qualifications, who know you as a person, what kind of a judge you're going to be. That's what's most relevant to us. The flash, the high profile is irrelevant.
And a follow-up to that is how often should an applicant send updates to the governor's office while they're waiting for this amorphous, enigmatic process to play out?
That's a tougher question. It's getting easier though as the clock ticks on Governor Newsom's time in office. You know, from my perspective, it's hard to put. We don't want to hear from you every week. You know, it's not helpful for us to hear about how your commute went this morning or anything like that, right? But if there's something that comes up in the course of your career that you would have put on your application if you were submitting your application afterwards, right? Some major case, promotion, new association that you've gotten involved with or have been promoted to some leadership role. These are things that we would like to hear about. And letting us know in a kind of aggregated way, every 3 to 6, I would say 6 months, though I'm being conscientious of the fact that we don't have that many months left. Be judicious, I guess I would say, in how you organize this and think through whether, again, would you have put it on your application if you were hitting send on that application today? That's the time to update it.
Just Tapia, from your perspective, and we talked about this a little bit, but what are the ingredients that make for a successful bench officer from the presiding judge's perspective?
I think that's a great question. I think I alluded to it a little earlier, and you did as well. Intellectual curiosity, I think, is incredibly important because we don't know where you're going to be. Judge McKeekin, I don't know where you're going to get assigned. Depends on the needs when you take your oath. So you have to be open-minded. I've been shocked. I was just telling Justice someone this morning. I'm always shocked when I get a new judge to meet with a presiding judge. They haven't even taken their oath and they're questioning whether they're getting assigned. What do you mean I'm not going to a criminal courtroom? I find that shocking because I never would have done it. I don't think you ever would have done it. But that speaks to a lack of humility, a lack of really wanting to evolve as a legal professional. The best way to serve the public is to be open-minded and understand that every person's needs are just as important. It doesn't matter what type of courtroom or discipline it's coming from. So I think you need to have intellectual curiosity. I think you need to be humble. And I cannot emphasize that enough. Humility is going to help you in this career. The moment you start losing humility, I guarantee you're going to start running into problems. And I see it. When I was the assistant presiding judge, I oversaw the complaint process. Our court averages anywhere from 700 to 900 complaints a year. Most of them, people are just upset about the outcome. That is not an issue. I have to get involved as the presiding judge, and when I was assistant presiding judge, when it's an ethical issue. And more times than not, it's temperament, which in so many ways is a lack of humility. One of the things that we've tried to do on our court is criminal practitioners. I'm very hesitant to put them in a criminal assignment. And I'm going to tell you why. It's nice that they have that experience, but chances are their first assignment is going to be in a misdemeanor court where all the lawyers are brand new and they are still learning their way. And the judge becomes impatient because they know what the answer should be for every single case. And they forget that the lawyers are still trying to catch up. So they are perceived as being impatient, lacking temperament, and prejudging cases. That's what I have seen. That is what 13 years on, is it 13 years? 12 years on the bench has taught me about judges, that I don't want to put them in a situation where they're going to fail. I want them to be successful. But there are certain things I can't do for them, which is ensure that they have intellectual curiosity, ensure that they have humility, and probably the other important factor, that they have a strong work ethic. Because I also get people that want to become judges because they think they're going to retire to the bench. That is bad. I mean, if you look at our workload right now, we have seen an increase in unlimited civil filings by 30%. The dockets for civil judges are crushing them. Dockets in every single discipline, family, dependency, they're crushing workloads. Be prepared to work hard. Be prepared to work more than just 8 to 5. That's something that you need to just wrap your brain around. If you think, and trust me, I was there when I was a young lawyer. What does the judge have to do? They just have to decide and move on. Yeah, it's not that easy. It can be very taxing, just decisions. I think you would agree with this,
Yeah.
Justice Zukin. Your first day, you're going to make more decisions on the bench than you've ever made in your career. Some are small, some are huge, but you're constantly making decisions. I joke with new judges, you suffer from decision overload at the end of the day. When I got home, my wife would say, "What do you want for dinner?" I'd say, "I'm tired of making decisions." Unfortunately, she's a judge now, so we could never decide. So that's what I would say you really should lean into. Being intellectually curious, humility, and having a very strong work ethic. Because our judges in our court, I don't have to tell Judge Amerian, Commissioner Albanese, and Judge Wasserman, it is a lot of work and you better be prepared for it.
Justice Zukin, I've heard you speak about the process and your mentorship panels, which I know are important to you. Building on what Judge Tapia just talked about with the importance of humility, can you also talk about maybe when humility gets taken a step too far and becomes imposter syndrome and maybe prevents otherwise well-qualified people from taking the plunge?
Sure, but I'm also keep veering off, and I
That's okay.
apologize.
That's fine.
Let me just say that your application is not the place to hide behind humility or to put in your application all of the things you're proud of. I mean, it's just the way you're going to convey it to the governor's office that has to have some humility. But that's the place where you want to shine. Okay, so just want to say, make sure that application, you are that wonderful lawyer and person that you are. Okay, imposter phenomena. So do we all know what it is, imposter phenomena? Some of you have it. I had it. Anybody else had imposter phenomena?
Still have it.
Okay, so, which is what, really? Okay, see? So it's when you feel you're not good enough. You're an imposter. How did I get into this room? How did I get picked for that position? If they really knew me, they wouldn't have made me an associate at that law firm, right? It's all those self-doubts that we have. That, I think, particularly in women and people of color, people of diverse backgrounds, afflicts us. And you'll never apply to the bench with those self-doubts. Oh, I haven't had enough trials. I've only had 5 trials, or I don't try cases. I haven't done enough motions. Whatever it is that you're thinking in your brain, that you're telling yourself you're not good enough. I'm not good enough as Mr. Hofmann. I'm not good enough as this person. Those kinds of comparisons will stop you from applying to the bench. I think that's the number one reason a lot of very capable people don't apply. So you have to change the narrative, right? Change the narrative, get a mentor. The best, and the studies have actually shown this, that one of the best ways to overcome imposter phenomena is to have a mentor that you trust, that can accurately reflect back to you who you really are and what your accomplishments really are.
No, that's, to me, one of the things when I have people who are thinking about this, or some of you that are here, I've literally had to drag you to the point at which now you realize you should be applying. But to me, those people end up making terrific bench officers because at their core, they're humble. And they know that they're not the smartest person in the room, or they don't go up there thinking they're the smartest person in the room. And I heard a great line recently that people who are correct the most are the ones who change their minds the most. To recognize that you're not, your first instinct may not be right. Be
Yeah.
open-minded and being humble and channeling that imposter phenomena into humility, I think, can be a productive trait, a very useful trait as a bench officer. I know we're starting to, Secretary Hofmann referred to the fact that Governor Newsom's time in the governor's office is nearing its end. Justice Zukin, you've had the privilege of having served on all of these committees at transition periods.
Yeah.
Can you give us some insight into what we might be able to expect as we transition from one governor to the next?
Sure. So I was chair of the Jenny Commission during one of these transition times, and at the end of one administration and then into the next administration, because the state bar decided to keep me on longer. So I saw the whole process with the new governor. The new governor will have their own application. So, but the secret that I've seen over almost 30 years of watching this, the applications are only tweaked. Nobody has started from scratch. So if you start working on the application and you end up applying in the next administration, you'll just tweak it. They're really very close, the applications. I can tell you Governor Brown's and Governor Newsom's were very similar because I've filled out both. So then there are no appointments, right? There are no appointments while they're working to find an appointment secretary. Then they find the appointment secretary, and that person has to work on the application. Then they have to get the process going, and it's a slow ramp up. It can be 4, 5, 6 months between they start really vetting candidates. But because I believe, and I have no crystal ball, but because conventional wisdom is the next governor may have similar values to this governor, generally speaking, for the bench. If I were you and you're running out of time with this governor, keep going. Join the mentor program, the LA Superior Court mentor program. Don't stop because the administration is about to change, but know that during that time when there are no, that sort of downtime, when either you can't apply or nobody's been appointed, there will be vacancies adding up, right?
Yeah, I think the lag from Governor Schwarzenegger to Governor Brown was about a year.
Was it a year?
Before he made his first appointments. And then from Governor Brown to Governor Newsom, the lag was almost a year as well.
Yeah, it was less.
So it takes some time for them to put the machinery in place.
And the other thing is, the governors have their own judicial vetting committees. Takes the new appointment secretary, unless they were somehow involved in the process in the previous administration, they need to learn the lay of the land in all the different areas where they have JSACs. So that takes them a while
That
too.
takes time.
Yeah.
I'd like the three of you to talk about other ways that people can perhaps audition for the job and audition the job for themselves, specifically as participants in the temporary judge program or even applying to be court commissioners in the meantime, while perhaps they're pursuing a judicial appointment in parallel. So all three of you could, I think, offer valuable insights into that. Secretary Hofmann, I'll start with you.
Sure. I frankly, I think you've probably identified the two central ones. The temporary judge programs, throughout the state, it's a wonderful, it's a great way to serve the community, right? You're helping judges who, as you've heard, are overworked. And helping them clear dockets, whether it's by presiding in small claims or managing settlement calendars or whatever. There are all these roles that temporary judges can play. And it's an opportunity to get a flavor of what Judge Tapia was talking about, right? The intensity of the decisions. I know someone, a friend from practice, who was thinking about applying for the bench. They signed up, they were doing the mentor program. They signed up to be a temporary judge. They presided a few days, and they decided they did not want to be a judge. And to me, what could be more valuable than that, right? You've heard how intense this process is. Imagine going through it, getting out the other side, being appointed, and 6 months in, you realize you made the biggest mistake of your life, right? And then the serving as a commissioner, is that, but exponentially increased because you're doing it every day. You're taking on several roles that judges actually undertake. In some cases, we see commissioners who are frequently, often get stipulated to handle matters the same way that judges would. So you get a flavor of what that day in and day out is like, and to demonstrate your abilities, and to meet folks in the community. So to me, those are tremendous opportunities to sort out, your own goals and to begin building that experience.
Justice Zukin, from a vetting perspective, what insight does that provide?
I think pro-temming is the best thing you could possibly do for the reasons that Mr. Hofmann said. When I went and pro-temmed, when I was thinking about the bench, I walked into small claims court. The judge that was normally there, that was his courtroom. He was 6 feet tall. They handed me his black robe. I didn't have one. I was a lawyer. I put it on feeling like an idiot. You can imagine what I looked like when I holding the thing up as I walked onto the bench, right? I said, this is not starting well.
Only you could pull it off.
Well, it was great. After that very first day, I went, whoa, this is amazing. This is, your mind is working fast. You're having to figure out things. Half the time I don't know if I got it right or wrong, but I had to decide. And I thought, gee, I want to do this again. So it does serve the purpose of helping you. I did traffic. That was a blast. It was like, oh, I love this. But if you have a concern about a lack of trial experience, I don't know of a better way to counteract that in an application than to show how much pro-temming you've done, because you put on the robe, you've got on the bench, or lack of courtroom experience, right? Because how about transferable skills? This governor cares about all different practice areas, as you've already heard. And some people don't ever get into a courtroom or haven't been there in 10 years. Is that right, Mr. Hofmann?
I think that's right. And that too comes back to the diversity of professional experience. You heard Judge Tapia talk about that. Is definitely something we value in our office. And it has included folks who, we have appointed people who were corporate attorneys. Literally no aspect of their practice involved going to court. But yeah.
So it's important. So that pro-temming is invaluable, absolutely invaluable. And I'm just going to go off in one more direction before we finish and say, being a judge is on the job training. And that's one of the values of being a pro-tem, because you're seeing it. You cannot study it in advance before going on the bench. You can go and observe. That's the best you can do. But until you put that robe on and you've got a witness on the stand and someone says, and a jury there, and someone says, objection, Sanchez. And you're thinking, what did that expert just say? And is it case specific? You may have known that that case as a lawyer and had a pocket brief on that line of cases. But when you're a judge and you've got an orthopedic surgeon and he's leaving back to Philadelphia in an hour and you've got to figure it out right now, it's on the job training. So pro-temming really helps with that, and know that there's probably perhaps no other way to figure out whether it's right for you.
And the other thing, before I give Judge Tapia the opportunity to chime in, there's a commissioner who I encouraged to be pro tem. She sat in my department, Kendra Thomas, sat in my department, and I came in the next day. She's filled in on a Friday. I came in on Monday and asked my staff how it went, and they said, "When is she coming back? We would rather have her than you." I said, "Hey, wait a second here. You guys have been with me for a couple of years. What happened?" She was fantastic. So it's a way for you to build your reputation within the court, because then what do you think my next thing was? I walked down the hall to Judge Doherty and Commissioner Mordetsky and everybody else in Van Nuys, and I told them, not that they were surprised, how terrific Commissioner Thomas was. And so you end up creating some career momentum that way, and you end up generating, broadening your audience of admirers. So you got to look for ways to, I think, establish a chorus of voices that are going to be saying good things about you when you submit your applications for them to look at. Tapia, do you have anything else you'd like to add?
No, I don't disagree with either Mr. Hofmann or Justice Zukin on the issue of serving as a pro tem. However, I do want to emphasize that I think that the biggest value is for the candidate to really determine whether it's something they want to do. Because look, I'm going to be perfectly frank with you. Serving as a pro tem is not the same when you become a judge, because pro temps sit in traffic courts, maybe small claims, maybe some family law matters. But at the end of the day, the work of the judge is very different. That's why I think the value really is for the candidate to just expose yourself to being in a courtroom. And I agree, you're going to develop some skills that will become transferable and valuable to the governor and to vetting committees, so they can see, okay, this person understands some evidence, this person can handle a courtroom. But I do think the value is more for the candidate. I have a different take on commissioners. There was a time and place, especially in LA County, where people became commissioners and it was a career, because all courts need commissioners to sit in certain assignments. Over the past now almost 8 years, it has sort of become an entryway to become a judge. And that's not a bad thing for those individuals or for the governor. We've had to change our vetting process for commissioners because of that. I think we're being much more mindful of checking certain boxes for our commissioners. But there was a time when it was a career, and we still need people to sit as commissioners, not as judges. But this is my sort of take on this. All of these opportunities speak more to what I think this governor values and what I think we should value in judges, which is showing the governor, showing these vetting committees that you're committed to something beyond yourself. That is what serving as a pro tem is all about you learning the job, but also that you are showing a commitment to something other than yourself. That is why the governor and vetting committees do a deep dive to find, okay, what has this person done? Assuming they have the bandwidth. Because look, working mothers, very difficult. Working fathers who do not have help, difficult to get involved with bar associations, difficult to do anything beyond that. That's understandable. And this governor has done a great job of recognizing that. However, if a candidate has the bandwidth to be able to get involved, what a better way to get involved than to be a volunteer pro tem judge, to volunteer with the Armenian Bar Association, to volunteer with something outside of yourself to show that you are committed to serving the public and the greater good. That is what I believe the value is of someone who commits themselves and volunteers to be a pro tem.
Judge Amerian, can I add just one further thought
Please.
about this? Because I'm going to undermine my own brand here, which is not wise, but I think it's important. There is one downside to especially serving as a commissioner, but to some extent serving as a judge pro tem in certain departments. And that is, if there isn't a lot of time between the sort of starting of those subordinate judicial roles and the application and vetting process, I have seen some folks, like you've heard about, who just day one start knocking it out of the park. It happens. Not more often, What sometimes happens is you get someone, let's say a career criminal defense attorney, signs up to do as a commissioner, as a judge pro tem, they're sitting in a family department. Now they are the person in the room who knows least about the law that they are managing. Okay. 2 weeks later, a bunch of people that are appearing in their courtroom start getting Jenny forms.
Oh, it's terrible.
Right. And now you've got all these, kind of self-satisfied family lawyers who can't wait to tee off on how little this person knows about family law. Well, of course they don't, right? They've been doing it for 12 minutes. I would like to say that our office gets that. I would like to say that the Jenny Commission and the JSACs generally get that. But people should just be aware that there's this risk in terms of how your reputation, you could be a stellar lawyer who's done nothing but amazing work for 20 years. And all of a sudden you've got these people piling on because of the, whatever it is, X number of times that you sat as a judge pro tem. And if people aren't alert to that, they may say, oh, well, this person must be terrible as a judge, right? So you have to just be alert to that and think about how you time out these different roles. And then if and when it comes up in the vetting process, how you explain yourself. So it's not to discourage anybody, but just to kind of see that off in the distance and try to prepare for it.
I do think this speaks more to the process, right? There are so many people that come in and say, I'm going to apply. What do I need to check? What boxes do I need to check?
Yeah.
And they do these things last minute. And when I say last minute, within the last year, this is something you should plan out so you don't have these issues. Because when you start trying to just pile everything on at the end, it's going to create problems like this.
How important are the ethnic bar associations endorsement committees that have taken shape over the last 10, 20 years to the process? What kind of role can they play?
Well, I don't want to say that the Armenian Bar Association is our favorite bar association. It's, but here among friends. No, it is very helpful, and it goes to something we've been talking about in various ways throughout the evening, which is this commitment to public service, right? Community respect. And there's another layer that I'll add in just a second. But again, what Judge Tapia said is critical, right? Let's just use the Armenian Bar Association as an example. If you have been a longtime member who shows up, and when you were a young lawyer, you introduced panelists, you handed out name tags at the desk, and you worked your way up, and you've been active, and now you're in leadership, and the Bar Association is endorsing you because they know you and they think you're wonderful, right? That's amazing. Very helpful. Shows commitment to community service, shows community respect. These are great things. If you joined 10 minutes ago, right before hitting send on your application, so you could add a bar association to your thing, and then you sort of finagle a letter that comes in kind of lukewarm, like, yeah, they're a member, hooray, right? That also shows and isn't great.
And we see that at the vetting committees.
Oh, yes.
We notice it too.
So, but from the governor's perspective, this you've heard the governor talk about California for all. That means diversifying the bench across every possible spectrum. That includes, race and ethnicity. And so, it adds value to show that you're connected to your community. The other thing that I will say is, for some of these, and the Unity Bar, which now is growing in Los Angeles, and started in Sacramento, but is now growing throughout the state. One of the things to think about is, if you're a trial judge, you will eventually have to stand for election. And I don't know what the percentages are. They're not very high in terms of people who get challenged. But people do get challenged. And knowing for the governor's office, saying this is someone who's out in the community, they have community support. That means that if there is a challenge at some point down the road, that's a person who then is going to have some backing, right? So that adds additional value. And I highlight the Unity Bar in particular because one of the central premises of the Unity Bar is that if they endorse you and you are challenged at the ballot box, the Unity Bar will come to your defense. That is like one of their core principles. And so, I don't want to assign that to any of the other affinity bar organizations because everybody's got their own principles, but that is a value add for sure.
Just in the interest of publicizing these things. The Armenian Bar Association does have its own judicial vetting committee. I'd encourage you to talk to Lucy about the information, contact information to be connected with that. And then more recently, the Middle Eastern North African Judges Association, which Judge Michael Poulos from San Diego is nice enough to slug his way through traffic to be here tonight. That he has been, I don't know where you have the time and energy to do everything you do for us on that, for that association. But we have our own mentorship program and appointment endorsement program. So I encourage you to get in touch with him on your way out tonight to get that information as well. All right, so I think we're in the home stretch here. Is there anything else that any of you would like to add? Let's start with Justice Zukin.
No, I'm just interested in questions.
Okay, Judge Tapia.
I just have one piece of advice, which goes back to the imposter phenomenon, which I tell people all the time, because I have to remind myself, if you're finding all these ways to talk yourself out of hitting send, stop, because there are enough people that want you to not hit send. So that's a signal to you need to hit send on that application. Don't talk yourself out of it.
All right, Secretary Hofmann.
A follow-on to that, which is, as you've heard, there's a little over a year left in Governor Newsom's term. In terms of that vetting process that I described at the beginning, the time is growing very short. There is not a deadline. People should hit send when they're ready. And as Judge Tapia is saying, ready before you think you're ready. Okay. There is no point at which we will stop taking applications, but our ability to vet and get people through the system and get them on the bench starts to drop rapidly in the coming months. And so what I'm saying is two things. One, get your application in as soon as you can. Two, don't decide not to hit send because you think it's too late. Because as I think it was Justice Zukin commented, the worst thing can happen is we don't get a chance to fully vet you. We don't get a chance to appoint you, but you've done 9/10 of the work and can be first in line for the next governor. So it's not wasted time. Okay.
So I will have the last word.
Great.
I just was angling for the last word. The LA Superior Court Mentor Program now has an expedited program taking into account, I think they have them throughout the statewide, but here you can still sign up for a mentor judge. They're going to be doing pairing, I think, very soon for mentors and mentees. So you can, and it's going to continue beyond this administration. So don't think you have your chance of getting a mentor judge is coming to an end.
And you don't need to just wait for that program. If you're in a courtroom or you develop relationships with any judges, ask them. Don't be shy about that. We're basically all empowered and expected. The tone that Judge Tapia, before him Judge Jessner, set for all of us is to basically be talent spotters and to try to identify good candidates and encourage you to apply. So that's why I'm stubborn and relentless with the people that I think that I have come into contact with that I think would make fantastic colleagues, because that's ultimately what we're doing. We're trying to pick and spot the people that we want to work with. We want worker bees. My day, just in a snapshot to give you, we're asked in Van Nuys, we're asked to volunteer to help with settlement conferences on either unlawful detainer cases or other unlimited civil cases. And we're asked to volunteer to take unlawful detainer trials or other unlimited civil trials that are coming up against the 5-year mark. Basically, we're looking for teammates and people that are willing to be worker bees. And like Judge Tapia said, this is not the place to come to retire. Please don't, because we have too much to do to have that. That if maybe back at another time that was what was expected and looked at as a career in the judiciary, but not now. As our three panelists have said, we're looking for people that are going to be heavy lifters. All right. So now the time you've all been waiting for, questions. This is not the time to be bashful. Yes, Lucy.
I'm gonna go first just because I want to follow up on the comment that you made about the Armenian Bar's Judicial Evaluation Committee. I want to acknowledge Rafi Zarunian, who is a part of that committee. Judge Fugera, who's all the way back here, she's a part of that committee. Armin Akaragyan was here, he's a part of the committee. Our committee members are from San Diego all the way up to the Bay Area. We cover the entire state. And so while we think that the diversity on the bench is important, we think the commitment to the profession is even more important. So we're very principled when it comes to the letters that we write. We make sure that we have turned over every stone. We are committed, as I said, more to the profession and the process. We will attend programs like this so that we have a clear understanding of what this governor is looking for. And then we will outreach. We rely on our sitting judges and commissioners who will come back around and encourage people to apply. And then we'll try to make sure that we do the process justice by being true to what we think that you would want. So you will see, we will either not write a letter when someone comes through, or we will write a very short, they're a member kind of letter. But the ones where we get really into the details of the individual, it's because we've studied that person. And if they're going to be representing us on the bench, we want to make sure that we've got 1 or 2 chances at writing a letter and having it be successful, that we put our best foot forward. So we've been very blessed to see a couple of appointments come through just recently. And so we're very grateful for that. But I think what those people don't realize is that their workload has just tripled, because we keep going back to them and asking things like, can you come by and speak to this high school moot court class? Can you invite them to the court to be part of the Walala luncheon program? So, and they always say yes, and we're very, very grateful for that. So I want to say, acknowledge them. They do a lot of work in participating, but the one person I do want to thank is Judge Tapia, who 2 years ago at our judges night literally shook me and said, what is your bar doing when it comes to appointments? And then he's made the commitment to help us out, and here we are today. So really, thank you very much. And then Justice Zukin actually did that at her swearing-in ceremony. She said, I'm told I need to talk to you about putting on a program like this. And so we're very grateful to all of you. And then you flew down for this event. So thank you very much. But anyway, I'll just let people ask questions.
All right. Fantastic. Thank you, Lucy. Who would like to go first with a question? Yes.
Hi there. I'm a solo practitioner. I've been solo for over 10 years. I don't have institutional support, DA's office, law firm. What do you recommend for me to have my application stand out or not be dinged, perhaps, because you don't have a secretary to talk to about my temperament or what have you?
One of the things you can do is make sure you have community engagement. Show that you care about the community, because as you heard Judge Tapia, it's public service, right? Both Mr. Hofmann said too. I think that can be very important. A network of people in the legal community that you work with, whether it's in a bar association. Pro-temming if you have time, I also still think is an excellent idea. But your application doesn't have to look like someone from MoFo who has, a different look to their application.
So we've had folks get appointed who were coming from solo practice. you know, and not a few, I mean, several. And keep in mind, it's not just staff and people like that, it's your opposing counsel, it's the judges you're appearing before. Now, you know, we have seen the occasional application come through where just the nature of someone's practice was so isolated that it was hard to shake loose information. And the JSACs and the Jenny do their best when it comes to that. It is tough, and I think Justice Zukin has identified the right kind of path to address that. But recognize that one of the statutory factors there is that community respect. And so, you know, if your entire job is, you know, like doing corporate work by yourself in your office, and there's really nobody who can speak to your credentials, it can be a problem.
I have one other piece of advice, which Justice Zukin mentioned earlier, which is get a mentor. Because sometimes the mentor is going to help you identify things within your background, within your practice area to highlight in your application that you wouldn't have thought of. I mentioned earlier, when you have the bandwidth to get involved in the community, it's a good thing. What about those folks that do not? Well, I can tell you, even those individuals probably have something in their background that will help them. I'll give you an example. A working mother who doesn't have time to get involved with the Bar Association, but is involved with PTA, is involved by volunteering at their children's school, is involved in other ways. Again, showing a commitment to something beyond themselves. But the only way to really identify these things in your background, in your practice area, is to get a mentor.
Yes.
I have a question about the mentorship program. Is that something where you would just go online and you can sign up for it?
So I would go to the LA Court website, www.lacourt.ca.gov. And you don't even have to go search. There's a help box. It is called Court Help. You type in their Judicial Mentor Program. It'll take you straight to the page where you can sign up.
Thank you.
Yes.
So you all talked earlier about sort of the process. Mr. Hofmann talked about, you know, after you get to certain committees, if you get to Jenny, then you get those criticisms, which are sometimes some of the most demoralizing moments of your life. They certainly were for me. What are your tips about how best to rebut those criticisms?
Good question. Don't be defensive. Don't be defensive. When you get, you're talking about in a Jenny interview?
Yeah, I mean, I got
right.
Prepared.
Many
Well,
of us.
no, I don't mean in the interview. So I appreciate that. Thank you for that distinction. Are there things that people can do? You get this letter that says, here are the corroborated negatives about you. And then you start scrambling and thinking, how can I explain this? Are there any tips about how best to explain it, other than don't be defensive?
Well, it depends on the criticism, right? I mean, the don't be defensive is a big one, because I think what you really are talking about is the interview. That's the first step where it has to be dealt with, right? You just can't be defensive. You have to be self-reflective. It's always better to say, you know, I've really tried to examine why somebody would say that I'm a jerk on the bench, or whatever they said about you, that I can't handle complex issues, or whatever it might be. That is a time for self-reflection, to say, oh, I know exactly who said it, right? There are the candidates that will say, oh, it was Fred Smith. That's who that is from. That's not productive either, because you're probably wrong, right? I think it's really be self-reflective. Don't be defensive. Give the best answer you can, given whatever the criticism is, as to why it is not you, fundamentally. That's how, I don't know. What do you think?
I would add, I agree. And I would add two thoughts. The first one, it kind of comes as in itself as two thoughts, but one of them, which I think dovetails with what Justice Zukin was just saying, is on the one hand, take it seriously. On the other hand, recognize that the standard for delivering a criticism is fairly low. That substantial, credible, and corroborated as a practical matter means something like 2 or 3 people said something about you, right? And in LA County, on average, the Jenny Commission hears from 100 to 150 people, right? So recognize on the one hand, you've got to take it seriously and be self-reflective. And on the other hand, recognize that it may be a very small number of people who've said that. And so don't own it to the extent that you decide, oh my God, this is who I really am, if you don't think it is. Which is a difficult thing to balance, but you're talking about being a judge. That's kind of, what we're talking about, right? Being judicious, humility, courage, all these things. The other thing I would say, just to add on, in addition to addressing it in the course of an interview, is that if there's someone in your life who can speak to this issue, whatever it is, right? They can write a letter or an email to the investigating commissioners. And that is something you see people do sometimes. I think you have to be judicious about that as well. This person has a reputation for being super mean to, people they supervise. You get 2 associates that you're still supervising to write you a letter that says, no, he's great, right? That's okay, right? So, think about that, right? But I think you can look to support. The trick is, in the Jenny process, you get 4 business days as a practice. That can make it hard to pull that off in time, but it is an option.
And you don't want to do the reverse. You don't want a lobbying campaign.
Oh, yeah.
You don't want to lobby the Jenny Commission with 15 letters that come in 48 hours after you've gotten your criticisms. You have to be judicious.
Thank you.
Next question.
I have a question.
Yes.
How when someone's appointed as a judge, you see their political party affiliation a lot of times listed next to their name. Does it matter what a candidate's political party affiliation is?
No, it really doesn't. I have a cousin who's a Republican, and he likes to send me a text every time there's an announcement, and every time he says, all different. And then I respond the same way every time, which is, no, it's not, and it's not. The governor, I don't have the numbers off the top of my head, which is, I think, in part an answer to your question. We don't think about it that seriously. I mean, we are alert to questions of political ideology that a person can't set aside, right? So if the nature of your I'll flip it, right? I was talking to somebody who was clearly very progressive and talked about how important their online activism was to them personally. And I can't tell them what to do, but I was able to sort of identify some of the basic principles of being a judge. Like, look, be a judge, you can't spend your days on Instagram posting, how mad you are on various political issues. And I was like, well, yeah, but this is really important. Like, well, you got to decide what's most important to you, right? So I think the question is there something about your politics that says you can't rule without bias? Can you rule impartially? Can you rule courageously? But no, the governor has appointed Republicans, has appointed many folks who no longer affiliate with the party, and of course many Democrats.
Does that include, like, if you're registered as an independent?
Yeah, absolutely.
Thank you.
Good question. Next. I know enough of you to know that you're not this quiet.
They're hungry.
They might be hungry. Yes, go ahead.
I don't mean to hijack.
That's okay.
But I
think we have a question online too, so go ahead.
So if somebody comes from an administrative law background, for example, they appear before the California Workers' Compensation Appeals Board courts, and then they apply for a position to be a judge with the Superior Court, is that administrative background seen as a negative, even though they may have some experience with civil matters as well?
No, I mean, that fits into what we were talking about. I guess we didn't touch on it all that thoroughly, but one of the elements in the statute, and it's something we take seriously in the governor's office, Government Code 12011.5, keep saying that because it's worth reading, is legal experience, That's one of the factors. And then it defines legal experience, quote, broadly. And there are a whole bunch of things. It lists like 12 different examples. Administrative law is on there. You know, and so it is not a downside. And you heard Justice Zukin talk about on-the-job training, transferable skills. You know, you may need to learn the evidence code, depending on the nature of your administrative work. Like maybe you haven't dealt with that as much. I don't mean you, I mean the hypothetical you. But it is not, there's nothing about that is like a red flag of no.
Thank you.
I know we have a question online, I think. Lucy, can we
I don't
unmute
know
that
if
person?
you can unmute them. I did ask that they type their question in the chat, so let me. I'd have to figure it out.
All right, in the meantime, while that's happening, anybody else with a question?
I have a question.
Yes.
You talked about lobbying a little bit, and sometimes when you say you're interested in being a judge, it seems like people come out of the woodwork and say, "Oh, I know, you know, Mr. Hofmann, or I know, I'll send them a text, or I'll send some information." Is that something we should be asking for, or telling them to not do, or how do we approach that? If someone is genuinely trying to be helpful and says that they may have a contact that knows someone to know someone.
I guess, you know, I don't mean to keep coming back to this because it's going to start to sound obnoxious, but it's the right answer. I would say be judicious about it. You know, I think I said this already, but we're not looking for how many fancy people can you get to support, right? We're looking for information that goes to the question we're trying to answer, which is what kind of judge are you going to be, right? That said, it is helpful when someone we know or trust pulls us aside and says, "Hey, you should really look into so-and-so because I think they're great and here's why," right? Based on knowledge. And, you know, I would never turn down help from someone who wants to help. But the flip side of that is, you know, as Justice Zukin was kind of suggesting earlier, you know, we get 50 letters, somebody starts a call. Maybe you're not showing good judgment, but it's very, you know, it's so individualized. It's very hard to say what the right approach is. It's, you know, part of it is we've appointed many people who didn't get a single letter of recommendation, not one. Not a single person who buttonholed me or Secretary Cespedes and said, "Oh, you know, this person is so amazing," right? And we have people who, you know, see broad community support. There's a whole range, very individual.
Lucy?
So there's two questions online from Yvonne Carrick. The first is, are the requirements for being a temporary judge or commissioner the same as being a judge? And the second, are there any requirements for joining the mentor program?
No and no. So if you go on the Superior Court of Los Angeles County website, you will find the requirements for serving as a pro tem. There are some similar requirements in terms of how long you had to have served as an attorney. But other than that, it's different. We're not governed by the government code section like the judicial appointments process is. It's just a great way to get experience. There are also no requirements for getting a mentor. I always encourage people to get a mentor before they hit that 10-year mark. Again, so they could start planning out this potential career. And if you go on the course website, it'll tell the candidate what they need to do to get a mentor.
But I'd like to add that you have to be in good standing with the state bar in order to be a part of the mentor program, because that's checked.
And also to be a temporary judge.
I mean, when I was at one point, I was on the temporary judge committee, and one of the responsibilities of that committee is to vet applicants. And so I had a little bit of a taste of what Justice Zukin and Judge Tapia and Secretary Hofmann do on a daily basis with their responsibilities. But, you know, we look at, you know, you're forced to disclose if you're a party to a lawsuit, if you've ever had any state bar complaints, things like that. So, you know, again, we're taking a critical eye towards the ethical component and the integrity, because we know that even when you're there as a temporary judge, you're a reflection of all of us. And we want to make sure that we have fulfill our obligation to the community, that the people that are going to be serving in, whether it's small claims, traffic, frequently those are the only times that a member of the public will ever cross paths with the judiciary. We want to make sure that those people still meet the same high level of quality and service that that the rest of us aim to give every day. All right, anything else? Lucy, did you have any closing?
I think, go ahead.
Sure. Okay, go ahead.
No, I just want to thank you again for your time on behalf of the Armenian Bar Association. I'm honestly, are no more suitable candidates to have been on this panel. It's very informative. I learned quite a lot, and I know it's not easy with your schedules to make yourselves available. So we very much appreciate it. If we can just get a round of applause.